So as I promised, I'm going to talk about naturalization process or how to become a U.S. Citizen today. And I'm going to actually give you general information. So definitely if you have any case-specific questions, because every case is different from the other, you can for sure call our office and discuss further about your case with us to evaluate if you are eligible to start the process of your naturalization or becoming a U.S. citizen. So today I'm only giving you a general information about what the process is, what makes you eligible, what makes you ineligible for your naturalization process. So who is actually eligible for naturalization, or who is eligible to become a U.S. citizen? There are basic and general requirements for people in order to be eligible to become a U.S. citizen. And one of them for sure is that you have been a lawful permanent resident. But we have two different lawful permanent residency periods in order for people to qualify, which is basically called a 5-year residency or a 3-year residency. So 3-year residency is for people who are married to a U.S. citizens, and a 5-year residency is just a normal requirement for everyone else. Of course, there are some exceptions and exemptions that I'm going to discuss later on. So now I'm going over naturalization eligibility for people who are going to file for their naturalization based on their 5-year residency, like being lawful permanent resident for 5 years. So the first requirement is if you have been a lawful permanent resident for at least 5 years from the date of filing your naturalization application, which is basically the form that you file, which is called the N-400 application for naturalization. You could either file that form online, or you could print it out, fill it out, and mail it to USCIS. So you have to, you should have been a lawful permanent resident for at least 5 years from the time of from the date of your filing of your N-400 application. And the second requirement is that you must be a person that is at least 18 or older at the time of filing your application. And the next requirement is that you have actually lived within the United States, or you have been living within the state or the USCIS district that has jurisdiction over your residence for the last 3 months of the date of filing your N-400 application. And also, and a note for students is, for students, they should have actually been living for that 3-month period at the state where or the jurisdiction where they are going to school, or if they're living with their parents at the place that their parents are they're living, wherever their parents are living for that 3-month period. And the next requirement which is actually the main requirement, and most of the time people have questions about this requirement, is having had a continuous residency during the statutory period, which is for this case that I'm talking about, is for the 5-year residency period. That you should have been having continuous residency in the United States as a lawful permanent resident, and for at least 5 years immediately preceding the date of filing your application. So this continuous residency most of the time is kind of confusing for people, and sometimes people are mistaken about continuous residency, and they think it's kind of similar to physical residency, which I will talk about later. But these two requirements are two different requirements, and they are not the same. And continuous residency means you should have actually, even though you have long-term trips outside the US, you should have been actually continuously living in the United States for the past 5 years immediately prior to filing your N-400 application. If your, for example, if your trips outside the US during this past 5 years have been over 6 months or a year or over a year, then there will be possibility that you actually interrupted your continuous residency, and you will have issue in the process of adjudication of your naturalization application. And I'm going to talk about it in detail. So, and also, what does in fact a continuous residency mean? It means that your actually main dwelling or your domicile or the place that you live should have been the United States. Like your residence should have been the United States during the past 5 years prior to filing your naturalization application. For example, if one of the things, for example, that would make a presumption that you have interrupted your continuous residency is, for example, if you have a job overseas and you are not actually working and living in the United States, so you have your residence outside the United States, or you have your employment outside the United States. And but on the other hand, if you have for example, a rental property, like you have a lease agreement, or if you own a place in the United States, if you, for example, if you pay mortgages, or if you have an employment in the United States, so that would actually would make it that you are actually following the continuous residency requirement for your naturalization application. Now, I talked about the trips over 6 months and also trips for a year or more. So what will happen if you had during the past 5 years immediately prior to filing your N-400 application, what will happen if you had a trip outside the US for over 6 months? So the law says if you have had a trip outside the US over 6 months, for example, 8 months, in a single trip during the last 5 years, then there will be a presumption that your continuous residency, which is a requirement for your naturalization process, is in fact interrupted. So what you need to do, you need to overcome this presumption. So meaning that you must show that even though your trip lasted over 6 months, you did not actually abandon your lawful permanent residency, and by evidence or documentation, you can show that maybe it was an emergency, that you were, for example, like these days because of coronavirus, like people are unable to get their flight tickets to come back to the United States, even though they did not plan to stay outside the US for over 6 months. But due to the emergency and due to the situation, they could show that they did not have the intention to interrupt their continuous residency or even abandon their lawful permanent residency. So that's one of the things. But you need to overcome that, because if you have over 6 months of period, over 6 month trip outside the United States during the last 5 years, immediately prior to filing your N400 application, there will be a presumption. So USCIS will in fact assume that your continuous residency is interrupted. So if a person is able to overcome that presumption and prove that that they did not actually intend to abandon their lawful permanent residency, if USCIS accepts that allegation based on the evidence that you're providing, then what will happen? They would most probably like grant and approve your N400 an application, and you will become a U.S. citizen if you have other requirements for sure. But if they do not and they deny your application because you were unable to overcome this presumption that you have actually in fact did not break or interrupt your continuous residency, then they will deny your application. And what will happen, after your last trip that actually made you ineligible, your last trip that lasted over 6 months, when you come back to the States, you have to count your days from that date till it's 6 months prior the anniversary of your 5 year from that date, because you're going to start to actually have another 5 year statutory period from the date that you come back from that long trip, over 6 month trip. And 6 months before the anniversary of your 5 year, then you will be eligible to start filing your N400 application. So that's for the 6 month period. And how about the 1 year? Okay. So if you have been outside the US for 1 year or more, so it's not like 6 months, which is over 6 months. It's even if it's 1 year and 1 year and 1 day or more. That means actually if you have been outside, there will be no presumption thing. USCIS officers must deny your application, because if you have been outside the US for 1 year or more and during the past 5 years, or even during the past three years, it's kind of like the same requirement, the continuous residency for both 5 year or 3 year residency. So USCIS must and will deny your N400 application, and you will not even have the opportunity to show evidence or prove evidence to overcome this denial, or to show that you did not have the intention, because you have been outside the country for a single trip for 1 year or more. So what will happen after your N400 is denied, then you will have at least 4 years and 1 day to start filing your application. But even though they say it's called a 4-year and 1-day rule, but even though you can apply, this does not guarantee that still your application is going to get approved, because at this point, like after the day that you come back to the US, after your 1 year or more trip outside the US, so you have to start counting again for the next 4 years in 1 day in order to be eligible to file for naturalization. But at that point, you must still show that you did not abandon your lawful permanent residency, and you will still need to overcome the presumption, because at that point there still is a presumption that you abandon your lawful permanent residency. So what you need to do is it's better that you wait for 4 years and 6 months after the last date that you came back to the US, after you've been outside the US for a year or more, because on that point, if you do not have any other issue, for example criminal background or good moral character issues, and you pass your civic test, English test, and all that, then you should be fine, and that's not going to be a problem. So it's better, even if you have this 1 year issue being outside the US, it's better you wait for 4 years and 6 months instead of 4 years and 1 day. Okay, this is for continuous residency. So please make sure that you qualify, and don't think that because only you have the physical presence requirement, then you would qualify for naturalization. I have had a lot of calls from people recently that they filed their naturalizations on their own, and they thought, oh, okay, even though I had over 6 months trip outside the US, or even over a year, so it's fine, and I qualify because I actually met the physical residency requirement. But then they get denied, and then they come to us to file an appeal, and we would tell them if it's just because of your residency, like USCIS is right, because you did not meet the continuous residency requirement, even though you actually met your the physical presence requirement. So instead of appealing, it's better for you to refile that now you actually have met the continuous residency requirement. Because I don't know if you know, like for appeal of N400 is about 700, and it's kind of the same as refiling your N400 application. So to me, if it's really not USCIS error, it doesn't make sense to file an appeal. But I mean, it's definitely case by case thing, and it's not like I say it's a general thing. So we have to evaluate each case. So that's about continuous residency. Now I go to the other requirement, which is the physical presence requirement for people who wants to file for naturalization with having their being a lawful permanent resident for the last 5 years. So for 5-year residency, the physical presence requirements is actually 30 months. So you should have been present in the US physically for at least 30 months out of the 5 years immediately preceding the date of filing your application. So it's 30 months period. And another point is that the USCIS officer should only look at this physical presence during this statutory period, which is that 5 year that we are talking about. But for continuous residency, the USCIS officer could look at the entire period. Like they could even look at your trips that you've had even after filing your naturalization application. But for physical presence, they must only look at that 3 month period during the past 5 years up until the date of filing your application, not up until the interview or your oath ceremony. The next requirement is that you need to also for I already told you, even for continuous residency, so you must actually meet the continuous residency up until the date of your oath ceremony, up until you in fact have your naturalization certificate in your hand. So for example, you cannot file your naturalization application and then you go for a trip and you stay outside the US for over 6 months or over a year or 1 year, because then your continuous residency will be interrupted. So please keep that in mind, but that's only for continuous residency, not for physical presence. And the next requirement is that I'm sure everyone knows that it's like you should be able to read, write, and speak in English, and you must also pass the English test and also the civic test, which is about the history and the government of the United States. So there are 100 questions that you need to study, and you would actually, when you go to the interview, the officer is actually having that test with you. If you are able to answer 6 correct out of 10, you would pass the test, and the officer would stop asking you more questions. And also you have to do the writing test and also the reading test. And for some people, they think that the English test is only for the civic test when they ask them about questions about the history and government of the United States. But no, it's the English test is for the whole process of for your whole interview. So if, for example, you cannot answer the officer's question when they are asking you about where you live, like they are going over your application and you cannot answer and you do not understand and you do not qualify for any exemption or exception that I will cover later, then you most probably will fail the test, because the English test is not only for reading and writing. You must pass the entire interview and you must answer the officer's question in English if you do not qualify for any exemption or exception. Now I'm going over to exceptions, accommodations, and exemptions. So if an applicant has any disabilities, he or she could request for accommodation, and if that accommodation is approved, the applicant will actually be accommodated at the day of the interview. It's kind of like helping the applicant to be able to have the interview with the USCIS officer. What are these accommodations if they are approved? For example, the officer might extend the time of the interview or the time of the examination, like for example asking the applicant so many times the question that they're asking about the civic test, and they might provide English sign language interpreter for people who are deaf, and or they might have even off-site examination. and or allowing relatives of the relative of the applicant to attend the interview with the applicant at the time of the interview. So these are for accommodation if it's actually approved by the USCIS officer that you need accommodation. Now I go over the English and civic test exemption. So the exemption is actually based on the age of the applicant. So if the applicant is 50 or older, 50-year-old or older, and the applicant have been residing in the United States as a lawful permanent resident for at least 20 years at the time of filing their application, prior filing their applications, then there will be an exemption for the English test for the applicant. So what will happen, the applicant would be exempted from the reading, writing, and speaking English, and the applicant will have could actually have interpreter at the time of the interview. So again, I'm gonna say the age. So it's 50 or older, and the person have been a lawful permanent resident for the last 20 years prior the date of filing his or her application. But the applicant still needs to take the civic test, which is like the full civic test, which is the history and about the history and government of the United States. But they could have interpreter even for answering the civic questions. The second exemption is for an applicant who is 55 or older and resided in the U.S. as lawful permanent resident for 15 years prior filing their application. It's again the same as the 50-year-old, and the English test will be exempted, and they could have interpreter even for answering the civic questions. The third exemption is if the applicant is 65 or older and the applicant has been actually living in the United States as a lawful permanent resident for 20 years prior filing their N400 application, prior that date, then they will not only be exempted from the English test, and they could have their interpreter at the time of the interview. They could also have a simplified version of the test. So it would be less questions and it would be simplified version. This is the exemption. Now I'm going to talk about the medical exception. So this is actually called Form N648. That a person who has any type of disability, or who has, for example, Alzheimer or anything like that, and the doctor, if the doctor actually approves with this form, then and also the USCIS approves, then that person would be also exempted from the English test, the civic test, or even both. It depends on the officer. The officer is the one who decides if the person should be exempted from English test, or they might say, oh, he or she, even with the disability, they could actually take the test. So only the English test is exempted, but they have to take the test, or they're going to exempt the person from both. But it all depends if it's completed. It must be completed by a medical doctor, and that are approved by USCIS, and also USCIS needs to approve this form. And the last requirement, which is also a general requirement for both 5-year residency or a 3-year residency, is that the person must be a must be a person of good moral character. So person of a good moral character does not have, for example, criminal backgrounds that might bar him or her from naturalizing in the United States. So for the bars, about the bars to good moral character, we have two kind of good moral character bars, which would, in fact, if the person has it, would in fact make that person ineligible for naturalization. One of them is called conditional bar. The other one is permanent bar. So what are conditional bars to good moral character? And what is the difference between conditional bar and permanent bar? For conditional bar, the adjudicating officer or USCIS will only look at the acts or convictions that would make a person ineligible under the conditional bar rule during the statutory period. So by now you should know what the statutory period mean. Like for 5-year residency is the 5 years prior to filing your application. For 3-year residency is the past 3 years prior filing your N400 application. So that is the statutory period that the officer is looking for any conditional bar. And examples of conditional bars are, for example, if applicant has one or more crimes involving moral turpitude, or if applicant has aggregate sentence of 5 years or more, or violate any law on controlled substance during the statutory period, except for simple possession of 30 grams or less of marijuana, and etc. Because there are a lot of acts or convictions that are included in conditional bar to naturalization. So if you think that you might be barred because you have one of the acts or convictions that would make you ineligible, or you are not sure, please contact an immigration attorney to evaluate your case and to see if your arrest or your conviction would in fact be one of those conditional bars and making you ineligible to file for your naturalization application. And then the permanent bar. So the permanent bar is not only during the statutory period. There are specific acts or crimes that if you have been convicted of those crimes, you will actually be permanently barred to naturalize and to become a U.S. citizen. For example, if you have ever been found convicted, if you have ever been convicted of murder, that's one of the examples that you will be permanently barred from becoming a U.S. citizen. And another one is if you have ever been convicted of an aggravated felony, which murder is one of them, and we have more crimes that are included in aggravated felony. On or after November 29, 1990, then you will be permanently barred from naturalizing or becoming a U.S. citizen. So, and also if you have ever been convicted of genocide, and etc. So there is a long list for that. So if you have been convicted or arrested of any crime, contact an immigration attorney to evaluate your case before filing your N400 application. Okay, this was about the 5-year residency. Now I'm going to talk about the 3-year residency, which is, most of you would know that when you are married to a U.S. citizen. So if you are married to a U.S. citizen and you have been living for 3 years prior filing your naturalization application with that same U.S. citizen, then you do not need to wait for 5 years in order to file for your naturalization application. The requirements is it's kind of is the same, that you must be 18 or older. You have been lawful permanent resident for at least 3 years prior filing your application. And the main requirement is that you have been not only married, but also you have been living in marital union with the same U.S. citizen spouse during the 3 years statutory period until examination on your application. So, and also you need to meet all other requirements. The only difference, like the continuous residency, the only difference is for physical presence. Instead of 30 months for 5-year residency, you must meet the 18 months of residency, physical residence in the United States as a lawful permanent resident. The remaining requirements are the same. That you must be a person of good moral character. You must pass the civic test or English test unless you qualify for one of the exemptions or exceptions that I talked about. And as I said in the beginning also, you will, for the naturalization process, the form is N400, so you file your form, and then you go for your biometrics appointment and for your fingerprints, and then you wait till you are called for your interview. And then at the interview, the officer will actually review all the documentation that you provided. We'll go over the form, the application with you, and to find that everything that you wrote in the form and filled out is correct. And all the dates, the addresses, phone numbers, and all the information that USCIS has is up to date and correct. And then if you pass, you will receive a letter within normally a month from USCIS that you will have your oath ceremony. You attend your oath ceremony, and after that, if everything works well, you will become a US citizen. So I want to again remind you that if you ever had a trip over 6 months or a year or more, please contact your lawyer or contact an immigration attorney to review your departures and arrivals in order to see if you qualify for your naturalization, because it's a very expensive application. Please do not file if you're not sure. First, make sure that you qualify and then you file, because if USCIS is right about your lack of continuous residency and you were wrong and you filed, appealing is not going to be a good option for you, and you might lose a lot of money there. And also, if you ever have been arrested, please also contact a lawyer to evaluate your case to see if the crime or conviction would actually be one of the crimes or one of the convictions that would make you ineligible to file for your naturalization. Is it a conditional bar? Is it a permanent bar? Or if it's nothing and you might qualify and there wouldn't be any issue. And also for public charge, I already discussed about it. Public charge does not apply during the naturalization process, so don't worry about public charge if you are ready to naturalize. Hope this workshop was helpful for everyone. If you have any questions, you can DM me, send me your questions. If you have any specific questions about your case, you definitely need to make an appointment for consultation. We're open Monday through Friday from 9 a.m. to 7 p.m. We will not have our in-person meetings or in-person consultations, but we're available through FaceTime, Skype, Zoom, whatever is convenient for you. Thank you and have a great evening.